Kira Kotukatu, welcome to the second episode of Legal Connection. My name is Jesil. I am with you tonight, and I'm really excited to be with you all. And let me know if you're watching, and I would like to shout out to you all. And yeah, welcome. And again, this is Legal Connection. I'm Jesil. I'm a barrister and solicitor of the High Court of New Zealand, based in Wellington, and I specialize in family law. And wherever you are today, thank you so much for tuning in. And our topic tonight is enduring powers of attorney. That's what we're gonna do, and I'm really excited to share about this topic because it is something that is so important. It's probably one of the most important documents you will ever sign in your entire life, but a lot of people really don't do this. So I hope that after tonight we'll be able to have some sort of clarity and understanding of what enduring powers of attorney is or are. Anyway, so this is our topic tonight. So we're gonna see what are enduring powers of attorney, who needs APA, and what happens when you need it but you don't have it, and who needs it, and the importance of enduring powers of attorney, and what do you need when you want to do it, and of course questions and answers at the end. Amazing. Hi Tracy Lee, watching from Palmerston North. It was lovely to see you yesterday. Hi to beloved Holden, my first time here. Thanks for inviting me. Of course, you're welcome. Ati Jill, hello, kia ora, mai, thank you very much. Shout out to all the people of Kinanawan Trinidad, Philippines. Amazing. Anyway, so that's our topic, and I just want to have some disclaimers tonight. So the information I will be providing tonight is not a legal advice, and it's not intended to be a legal advice. They're just sort of general information, explanation, something like that. If you have specific questions for your specific matter or particular matter, you should seek legal advice and you should consult a lawyer. Anyway, again, I'm Jesil, and thank you so much all for coming tonight. So let's start first with a story, okay? So the first story is about Juliet. Juliet is 70 years old. She has lived a very good life. However, she has dementia. And it was determined by the medical doctors and her family that it is in Juliet's best interest that she will be put into a nursing home so that she can be looked after well. However, Juliet doesn't have an enduring power of attorney. The question would be, can Juliet's husband or children, let's call them Kate and Leonardo, decide for Judith's medical care? Can they actually put Judith to a nursing home? Will the nursing home accept Judith? Well, the answer would be no. Sadly, no. And that's really sad to know, right? Sadly, no. It's a sad reality that Romeo, who is the husband of Juliet, of 20 years, can't make decisions for her because Romeo or Juliet doesn't have an enduring power of attorney. And here is Romeo's picture, really sad. And he was thinking, I should have, or Juliet should have made an enduring power of attorney sooner. And we'll come back to Romeo later on, okay? Another scenario is, there is Romeo again. It's a different Romeo. Let's just put a different Romeo, okay? And Romeo is a hardworking person. He is a construction worker. Okay. And life is uncertain. Something bad happens. There was an accident, and he was in the hospital unconscious. Of course, Romeo needs medication, right? Romeo has an enduring power of attorney for both health and property. Can Romeo's wife, Juliet, make medical decision for Romeo? Absolutely yes. Without going to court, without hassle, without any sort of difficulties, because Romeo had prepared for this moment, and he was he managed his affairs in such a way that his wife Juliet wouldn't have to go through. So let's really unpack what is enduring power of attorney. Enduring power of attorney is like a will. It is a legal document which sets out who can take care of your personal or financial matters if something happens, like what happened to Juliet, or what happens to Romeo, or when you lose mental capacity, but you are still alive. So that's the enduring power of attorney. So basically, it's just a document, giving legal authority to someone that you trust, that in case something happens to you, like you can't make decision anymore, or you become unconscious, or you get sick, that they can manage your affairs in personal, meaning your medical health, your welfare, financial matters, like what happens to your house, what happens to your mortgage, what happens to the rent, all that kind of things. But they are still alive, but they can't make that decision. So the person that you appoint to manage your affairs is called an attorney. Now, attorney in the Philippines means a lawyer, but in this context, it's just a legal technical term, meaning that someone you appointed, they are called attorney, regardless of their profession or whatever. So that's what we call an attorney. All right. So the law in New Zealand is different from other jurisdictions. So the law in New Zealand says that you know, any spouse or your loved ones cannot automatically act on your behalf if they are not legally appointed, meaning if they don't have an enduring power of attorney. In fact, as a parent, you cannot act for your children once they are 18 years of age. Of course, in New Zealand law, kids under 18 years of age, they will be under the guardianship of their parents. But when the kids are over 18 years of age, and they are unable to make that decision, then that's something that parents will need to think about. Awesome. So let's move on. So situations that you need an enduring power of attorney. Now, is it compulsory to have enduring power of attorney? It's not compulsory, but like will, it's also really difficult if you need it but you don't have it. So situation where you need an enduring power of attorney would be when you become mentally incapable, meaning you can no longer make decision. Right, the doctor said you have dementia, or you don't have a sound mind anymore, like basically old age, right? Or you have an illness, or again, like what happened to Romeo earlier, there was an accident, because life can be so tough and uncertain. Or you also need an enduring power of attorney when you are mentally capable but unable to act on your affairs. Like you are sharp and strong mentally, but you may not be able to sign the document because there is some physical incapacitation. Or maybe you are overseas and you can't come back to New Zealand to renew your mortgage or that kind of thing. So you need that legal authority, your attorney, to act on your behalf in case something happens to you, but you're still breathing, you're still alive. So that is the situation. Now, what happens without enduring power of attorney? Well, the only way for you to have someone managing your affairs when you lose that mental capacity is to apply to the family court. Now, when you think about family court, we are a family lawyer, it is really expensive. It can cost you at the minimum of $55,000 just to lodge an application to the family court. Delay, here is your wife in the hospital needing immediate care, going to nursing home, but she can't be there she can't be admitted to nursing home because the nursing homes would require an enduring power of attorney. So there's delays. It could take 3 months to 6 months. It is really stressful, right? This is a really stressful situations in the family. And then, you have to go through the unnecessary court process. And then you have no control. What I mean by no control, it's just an example. Romeo is the husband. They have two children. There's Kate and Leonardo. And Romeo said, "Now I want to be the attorney of my wife, Juliet." And then Kate said, "No, no, no, I don't want you, Dad, to be the attorney of Mom because you're already old as well. I want to be the attorney of Mom." And then there comes Leonardo. Leonardo said, "I'm the favorite son. I should be the one deciding for Mom." And there is three conflicts in that. So if there are three conflicts, there will be a hearing in the family court, and the judge will make that decision. And Juliet might not have wanted this, and the judge may choose someone else. If the family can't agree, the judge might choose someone else that is completely a stranger, or the judge might choose someone else that could not have been your choice. So you are not in control of that, right? So that's really important. Now, this is an example. So Juliet loses mental capacity. She didn't have enduring power of attorney. Her loved ones, husband, children, brother, sister cannot make decision for her. For them to be able to make decision for her, loved ones must go to the court, and that costs $5,000 or more. Romeo had an accident. He had enduring power of attorney. He said, "Well, if something happens to me, I appoint my wife. So the wife can make decisions on welfare and property, and therefore the wife doesn't need to go to court." And the wife only, probably Romeo only paid $250 to $600 to get his enduring powers of attorney done. So you see the difference. It's really different time. Now let's go to, there are two types of enduring powers of attorney. There is EPA property. So property means you appoint someone who manages your property or finances. And that includes your household expenses, maintenance, who pays the bills, engaging services and tradespeople, like say for example, oh, I want the house to be repainted, I want the house to be, or I want to renovate my toilet, all that kind of thing. Buying or selling property, overseeing relocation. So those are the things that you need. And the good thing about power of attorney, enduring power of attorney for property, it can kick in anytime you want. You don't have to wait until you become mentally incapacitated. And the reason for that could be like you might get stuck overseas and you want someone to manage your mortgage while you're away. Or the other reason is because you need to eat, right? And sometimes you just become physically incapacitated. You can't go to the bank, and you have someone that can manage your affairs. So you have the option whether to have your enduring power of attorney property effectively is effective today while you still have mental capacity, or when you don't have mental capacity. The second option, the second power is also important, is APA health. Now, this is about making decisions about your personal matters, your welfare, where you're going, medical care, all that kind of thing, deciding which rest home or nursing home you are placed in. But this only kicks in when you lose that mental capacity. Okay? And then, anyway, the key takeaways of this is there are two types of enduring powers of attorney. One is enduring powers of attorney property, and enduring power of attorney personal care and welfare. And again, enduring power of attorney is a legal document appointing someone that you trust to manage your affairs when you can't. Your spouse, partner, loved ones, children do not have an automatic entitlement or right to act on your behalf. So many misconceptions that, hey, if something happens to you, I have a wife or I have a husband, they will take care of me. No, they don't have that entitlement under New Zealand law if you don't have that legal authority, which is enduring power of attorney, to appoint them. All right? Without enduring power of attorney, court is the way so that your family can become appointed as your guardian. This is extremely stressful and expensive, going to the court, and we have seen it over and over again. And that's the reason why I'm really passionate about giving this legal information to everyone, because there's such a wide gap of, the public and the law, and we need to make law accessible to all, because these are the sort of situations that could have been avoided, right? So anyway, guys, questions and answers. If you have some questions, please let me know in the comments. I'm really happy to answer your question. Hi to Iyad Sidawi from Auckland. Hi, I'm not Jesus Iyad, I'm Jesil, but I know what you mean. Thank you, Iyad. Hi, Jill, thank you. Watching from Bohol, Philippines. Hi, Evelyn. Good evening, watching from Philippines. Brilliant. And hi, friends. I hope you're watching. We are watching. Thank you very much, Adelaida. All right, who else? Hi, Mai. Hello, attorney. Shout out to the people of Kinalawan, Trinidad, Bohol, Philippines. Hi to all the people of Kinalawan, Trinidad, Bohol, Philippines. Okay, and beloved Holden, my first time here. Thanks for inviting me. Well, if you have some questions, guys, please let me know, and I will be happy to answer them. Although I have received some questions from earlier on. Tracy, good evening. Watching from Palmerston North. Thanks, Tracy. It was lovely to see you yesterday. Right. Okay. Marie Rivera. So you have a question. In this document of enduring powers of attorney, do you need to come up with all types of scenario of illness, accidents, long-term paralysis, or can you assign one attorney for all of these health scenarios? Good question, Mary Rivera. Thank you for that. No, you don't have. You don't need to. You only assign one attorney for enduring powers for enduring power of attorney health. So for health, you only have one attorney, okay, to manage all your affairs, and then you can have a successor attorney. Meaning, if one attorney could no longer make decisions, then you have a backup. Okay, number 2, and as usual, can this be disputed if you were appointed, but their EPA wasn't discussed with you? What do you mean by that? Can this be disputed if you were appointed? Can you just clarify that second question? Can this be disputed if you were appointed, but their EPA wasn't discussed with you? Did you mean that if you appoint someone, is your attorney, i.e., say for example, attorney 1, you appointed him, and then attorney 1 doesn't want to do it anymore? Is that what you're saying? Come back to me in the comment, and I'll be very happy to answer that once it's cleared. All right. Evelyn Jamil. If I am in New Zealand and my family is in the Philippines, who can be my attorney? Well, great question. Well, if you are in New Zealand and your family is in the Philippines, then who can be my attorney? I think that's a really good question there. So I think we should discuss who can be your attorney. Okay, and you can make that decision, Evelyn. Shall we go there? Because this is also a question that was asked by one of the listeners. So I'm just going to go there. Who can be your attorney? I think I already have that. Right. Okay. So this is it. So what do you need when making an enduring power of attorney? So first, you need to have a sound mind. You can't have an enduring power of attorney when you no longer have a mental capacity. That's why it's important to do it as soon as you're 18 years of age. It's important to do it now. Now, next is attorney. Again, attorney is someone that you trust to understand and respect your wishes. You want someone intimate, someone that you know that they will have your best interests, right? They will follow your best interest. That's why a lot of people choose their husband or their children, and they discuss it with their kids. Let's say, for example, look, if I have something, look, if something happens to me, don't just put me, in life support, just pull it out, something like that. Okay. So so you need someone to be, intimate, someone that you trust and understand exactly what you want. They have to be 20 years of age, and they have to have mental capacity. Okay. They need to have mental capacity, and they are not bankrupt, because of course, if you appoint them as an enduring power of attorney property, it involves your property, and we need someone that can be trusted. So go back to your question, Evelyn. Well, if you're in New Zealand, I would suggest that if you trust someone in New Zealand, it would be easier if they are in New Zealand and they are resident here in New Zealand. Okay. So at the end of the day, it's really up to you, but it's important that they are residents in New Zealand. Thank you for that. Next, that's the beloved Holden. Beloved Holden, thank you for the question. Does the enduring power of attorney have to be witnessed by a GP? That's a really good question. Now, as you can see on the slide, for you to make an enduring power of attorney, a very good distinction between the will is you need a lawyer. You need a lawyer or a trustee corporation or a legal executive who has 1 year experience to do an enduring power of attorney. So it has to be witnessed, but the witness must be a lawyer. Okay? So you can't just witness it in a JP. You need a lawyer or a trustee corporation or a legal executive to witness it. So the way to do it, Dean, is you need to have legal advice. The law was changed in 2010. Before you can have it without a lawyer, but in 2010 the law was changed, and anyone wanting to have an enduring power of attorney, they must have independent legal advice. You cannot do an enduring power of attorney without a lawyer or a trustee or someone that is a legal executive. A JP is not qualified to do it because they are not a lawyer. Yeah, so a GP won't do it. Alrighty, let's go back here to Marie Rivera. If a family member assigns you as an attorney but didn't discuss this with you initially, yeah, that's not good, isn't it? I think my advice to my recommendation to you guys, that if you want to appoint someone as your attorney, you really have to discuss it with your attorney, because that's a huge responsibility. So there has to be some agreement before putting their name in the form, right? So, for example, if I appoint my brother as my enduring power of attorney, so I'll just go back here to see that. Here is my brother, Victor Cajes. He's my brother. He is my attorney. Okay, but Victor knows that he is my attorney. Before I put his name in this form, that means that he knows that whatever happens to me, he will be the one that will make that decision. And he is younger than me, and he's strong, and he's firm, and he is healthy. So I know that he will outlive me. He will not. I know that he will. He will be great. So you have to discuss it with a family member. Thank you for that, Mary. Now, can you refuse to be an attorney? Of course, definitely, you can refuse to be an attorney if you don't think you know the person enough, or if you don't want additional responsibility. The responsibilities, you can say, no, I don't want to be an attorney. Okay, I just want to greet Angie de la Chica Breguera. Hi, Angie. How are you today, my friend? Lovely to see you today. Right, here is another one. Judith Mendoza. Hi, Judith. Hi, how are you today? If you're a New Zealand citizen, would an enduring power of attorney done in New Zealand be accepted in other countries like US or the Philippines? Judith, no. The enduring power of attorney is only in New Zealand. Well, there are jurisdictions like the Philippines where we don't need enduring powers of attorney, so there's no point. Also, in different jurisdiction, i.e. different countries, we have different criteria or requirements. So your enduring power of attorney is only applicable here in New Zealand, and that's the law in New Zealand. Right. Right, Angie, very good. Okay, any more questions? I will have to go back up there. All right, I think I've answered all of that. So if you have more questions, please let me know in the comment section. Thank you, guys. Anyway, I am going to continue with my questions here. So let's go back to questions and answer. So I received this questions and answer before. What do you need when making an enduring power of attorney? So first is, again, you need to have a sound mind. Second, attorney. You need an attorney, someone that you trust, someone that understands your affairs, and someone that is not bankrupt, who is 20 years of age and has a mental capacity. You also need a successor attorney. Successor attorney is good as a backup when when your first attorney is unable to, if something happens to your attorney, something, they pass away, so you don't have to do your enduring power of attorney again, so you don't have to update it. So it's good to have a backup. You need to think whether or not you want your attorney to consult with other family members. This is really important. Say, for example, in our family, I'm the third of seven, so we're a big family. If my parents appoint me as an enduring power of attorney, then it would be wise for my parents to actually put a duty on me to consult the other six siblings. And that way, it forces me to actually consult decisions to my brothers and sisters. Also, you also have to think whether or not you want your attorney to give information to their brothers or sisters or to someone how they're performing their duty. Okay. And then, of course, you need a lawyer or a trustee corporation or a legal executive, because you need legal advice before an enduring power of attorney can be effective. Next. Okay, what do you need when making enduring power of attorney? So this is an example. This is one of the forms. There is a specific form that you need. You need to fill up, and then once you fill that up, we can also do it. But if you want to do it, you can just fill it up, and then we can check it in our office, and then we will be able to provide you legal advice, and we attach our certificate of witness. Now, difference between a will and enduring power of attorney. So thank you for this question. This is really good question. Okay. Um, Will kicks in only when you die, right? The will is just there. It's just like life insurance, like the life insurance is there, but when you die, that's where when the payout comes in. So the will is also like that. A will is only there. That's only like really helpful when you die. Enduring power of attorney kicks in when you are still alive. So will for the dead, enduring power of attorney when you're alive and when you could no longer make that decision. Next. Difference between general powers of attorney versus enduring power of attorney. Good question. Thank you for that question. Well, I think you're talking about ordinary power of attorney. So the ordinary power of attorney in the Philippines or other jurisdictions, they call it special power of attorney. So the SPA gives a specific power for a specific task. Example, I give you power to inquire about my GSIS payment in the Philippines, or I give you power to loan on my behalf. So that ordinary power expires or becomes ineffective when you lose your mental capacity, right? So the moment you lose this, it's gone. Or when the moment that the task is finished, it's also gone. So the power is very specific and very limited. Whereas the enduring power of attorney, it continues on even if you're called the donor because you donate that power, loses mental capacity. So that's the difference. And it endures, therefore it's legally binding, right? It's legally binding, therefore it is enforceable, and it will be accepted by the nursing homes, by the retirement villages, or even in the hospitals or in the banks, with your mortgage, with your house, with your bank accounts and all of that. All right. So, thank you guys. Again, that's my number there. I'm just going to check if you have some more questions here. All right. Judith, how can a power of attorney be revoked? Really, really specific, Judith. Really good question. Really good question here. How can an enduring power of attorney be revoked? There's only one way to revoke it, Judith. You will need to write to your attorney. So to revoke it, it has to be in writing. You can't revoke it orally. So that's the difference, right? Because, for example, the will, you can just change it without informing the people in your will. Whereas enduring powers of attorney, you have to send notice of revocation to your attorney, to your successor's attorney, and to the people that you put in there. So you have to say, I revoke your power, blah, blah, blah. If you need assistance, we can also help you with that, Judith, but thank you. Who has the power to revoke it? Well, you can revoke it, Judith. You can revoke it. The donor can revoke it, or the court can revoke it. Say, for example, if you lose mental capacity and the court is kind of like a guardian, or like the court is kind of like an overseer of whether or not the attorney is actually doing their job. Because sometimes there are abuses, right? Sometimes elderly abuse is quite, it is happening in New Zealand. So the relatives, the social workers, the medical professionals can actually report it to the court, and then the court, if there's a case, then at the end of the case, at the end of the proceedings, the court can say, I'm going to revoke your power because you've been abusive, something like that. Okay, more questions? Any more questions? Please send it to me. Really good. Thank you, guys. Good session. If you don't, so this is from Marie Rivera. If you don't feel, I'm just gonna read it here. If you don't feel that anyone is capable of being an attorney, example, due to their own financial health situations, can you assign an organization, a hospital, law firm, to help deal with property health decisions? Yes, absolutely. You can. You can do that. Um, you can assign it. Mary Rivera, you can ask a law firm, like somebody in the law firm, not just a law firm, someone, like specific person, or a trustee from public trust. How does the attorney get notified? Did you have to let them know? They will be notified because you have to ask their permission first. Is this the similar case to the will where I should let the attorney know in advance who to contact, where to find a pay document? Absolutely, yes. In fact, you are responsible for keeping your enduring powers of attorney. So you have to let them know where you put it, where you put it in the end. Okay. So thank you. Is there any more question? I would really love if you have more question there, please let me know. I would love to do that. Um, it's wonderful. It's really good to hear. I'm just reading comments here. Um, thank you guys. Right. Any more question? I'm just reading some of the comments there. Right. If you don't have any more question, if you have no more question, I think that would end our live. So I just want to greet everybody. So if you are watching today, thank you guys for watching, and please, if you find this live helpful, you can share this on your profile, on your Facebook page, or on your Facebook profile. There is another one. Okay, we are eating while we're watching you. Thanks, Judith. I hope that it's doing well, and it's great to see you live. I know, Judith. It's actually different, isn't it? Because you hear me on the radio, but now you see me, my face, it's talking exactly right here, right now. Yeah. Okay. So Virgilio, watching from Cebu, Philippines. Oh wow, thank you. I hope that you are doing well, and thank you so very much. Okay, who else is watching? All right, I think everyone is watching, right? So great. I found your program so organic. What do you mean organic? Oh, thank you, Judith. I hope I feel like it's a compliment. Okay, I think, guys, again, thank you all so much. And thank you for the feedback. I love it. I love it too. I'm glad that you love it. Right. Any more questions? Please let me know. So, right, there's more comments here. Right. Very informative. Thank you, Angie. Do you have enduring powers of attorney already? If not, let's suss it out. Right. Let's go back to our PowerPoint here. Again, enduring powers of attorney is really important. Right. So thank you, guys. I think these are the key takeaways. Again, APA is a legal document appointing someone that you love, you trust to manage your affairs when you can't. And in New Zealand law, your spouse, partner, loved ones do not have an automatic right to act on your behalf, contrary to popular belief. And without enduring power of attorney, the court is the only way. And again, I'll show you how hard it is to go to court. So see, Juliet has no enduring power of attorney for her loved ones to apply to family court. They may have to have $5,000, and it will continue because every 3 years, when it's the court who appointed the welfare guardian, every 3 years it will be reviewed by the court, and then you have to pay it again. The expenses is from your estate, so you have to pay it. So, and then the other one, Romeo does have an enduring power of attorney, and he only paid $250 to get it done, and then it's amazing. Okay, another question from Aisha. Aisha, thank you for your question. I just need to go back here. What happens to those who are deemed fit to go to a dementia unit but had no APOA? There are two things that will happen there. First is the family will need to apply to go to court, and I hope that, and the complication there, Aisha, if there is no family, right? If there is no family, then who will apply for them? It will be the social worker. Or if the family are unable to, or if the family is a high conflict and they can't agree who will apply to court, it is likely the social worker will have to apply to court first in order for the social worker to have that order or that power to put that person into a dementia unit. And the second thing, Aisha, is the dementia unit will not accept that person without the enduring power of attorney. So that is tough. So again, the answer there, Aisha, is court. And the hard part there, Aisha, is the court may make a decision who, the family may not like. So thank you for that question. Really good question, Aisha. I really appreciate that. Right. Another question there. I'm just gonna go back to you. Casa Alegria Bohol, an oasis of tranquility. Who is this person? I would love to go to that oasis of tranquility. In the absence of APA, who has the right to take care of a father? Well, again, oasis of tranquility. If there is no enduring power of attorney, you will have the family member. Any family member can apply to take care, to be the welfare guardian of the father through the court. So they will need to be appointed. They need to be legally appointed, and that will be a court process. So the family, the direct family, the immediate family can apply to court. And I hope that there are no conflicts there, because if there are conflicts, then they will have to fight who is worthy or deserving to look after the father. And that's one thing we want to avoid. Like if you are, if you are the person, you must suss out your enduring power of attorney. So it is clear, to your kids that, hey, child one, I want you to be the attorney. Child two, I want you to be the backup attorney, the successor attorney. And child 3, 4, and 5, then, you have the right to be consulted. Okay. Thank you. Next, beloved Holden. Thanks, Attorney Jesil. Very informative. Oh, you're welcome. It's my pleasure. Next question from Aisha. And what are the criteria of a sound mind? This is a prerequisite to appointing an enduring power of attorney. Oh, very good. That's a really good question, Aisha. So I think one of the things that we need to prove if someone has legal or have a sound mind would be, one, they are able to actually communicate that decision, right? They are able to understand the nature of the document that they're signing, and the lawyers are really skilled to interview these people. Like, how old are you? I'm 70. Where, like, are you able to actually, where are your properties? What happens if your properties are, all this kind of questions? And she will say, I'm hungry, all that kind of thing. So there has to be an understanding that the nature of the document they're signing. They're able to communicate that decision, right? They're able to communicate that decision, not just like rehearse it or memorize it, right? Or something like a rote learning. Yes. So I'm just gonna go back to the article I've written about sound mind, because I think that's really really helpful, Aisha. So I'm just gonna say, very good question, and I think it's really important to discuss about that. So first is they are able to communicate the decision. Okay. Second is they're able to understand what they're signing. And the third is they're able to actually weigh up the pros and cons of that, right? And yeah, so those are what we call a sound mind. And of course, the best person to do it or to assist if the person has a sound mind would be a medical professional. It could be geriatrician or people that assist. So sound mind really is is something that we the lawyers are able to actually think, oh, that person is good, that person is not, is no longer good. Next question. I'm just gonna read what other um question there. Thank you. Last question. Right, Ash's question is, would you recommend migrants to appoint an enduring power of attorney how soon? Well, migrants not only really, it's not just about the migrants, it's for everybody. Like, as soon as you are, as soon as you're 18 years of age, you should do an enduring power of attorney, especially to our migrant communities here. You come here to work, and a lot of the work are heavy duty, like carpenters, construction workers, and sometimes we don't know what happens there. Some work, some type of jobs are prone to accidents, so it would be good to have that in place just in case something happens. And how much is the cheapest EPOA that struggling migrants can afford? Well, how much really is very dependent. From our experience as a law firm, we charge per hour. So the cheapest we can do is 250 per hour. So probably for one person, we can do an hour of enduring power of attorney. For some law firms, they have fixed. For example, in the firms that I know, they have, say, a package. Say, for example, we have $400 for an enduring power of attorney for one, and if you do it for two, you only pay 595. So I know a firm like that. But for our firm, we only charge the hour that we do. So yeah, for me, I only charge the hour that I only charge really the time that I spend on that. Can the enduring power of attorney be challenged by third parties? Absolutely, Judith. It can be challenged by again by social workers if they think that. I don't think that enduring power of attorney can be challenged first if there is suspicion that you the donor first and foremost don't does not have a sound mind. If there is suspicion that actually this was done when the person didn't have a mental capacity, so there is a possibility that it can be revoked. Also, again, if there is suspicion of your attorney being, not doing their job properly, then that could also be challenged. All right, so that's a good one. Right. Is there any more else? Thank you guys for that wonderful question. Again, really great question there. Is there anything else? I'm just like typing here. Thank you, everybody. Thank you for your time. And again, if there are no legal questions, I'm happy to just end this. Right. Okay. All right, guys. I think I have answered all the questions. Thank you so much. Our time now is 9 o'clock, and it's really my pleasure to be with you all. And last one here. Right. I'm just reading all the comments, but everything is all good. Right. Alrighty. Okay, I think I've answered everything. So thank you, everybody. And thank you, Judith, for the feedback. And thank you, everyone. And have a good night. Have a great week ahead. And again, please share this information to anyone that you think might help them. And again, my name is Jesil, and the details are there. And thank you again for your time. And kakitiano, good night po, Mari. Mayong gabi. Magandang gabi po sa inyong lahat. Bye-bye.